بسم الله الرحمن الرحيم. طلاب الفرقة الثانية شعبة اللغة الإنجليزية. Welcome back to our online classes for the course of Theory of Obligations Contract. This is Dr. Ahmed Hamza Mansour. Please, if you do have any questions, contact me through this emails about the content of the class. Today, inshallah, we will speak about two topics. The first topic is the earnest money, دفع العربون وفقا للقانون المدني. The second topic will be about representation, النيابة بالتعاقد. And you will find it in the mentioned pages here. The first topic that we will talk about is the earnest money. From looking into the appearance of this term, or the literal meaning of this term, it means paying a specific amount of money in a contract. The whole issue is governed by Article 103 in the Egyptian Civil Code. It particularly mentioned that in the absence of a clause to the contrary in the contract, the payment of earnest money at the time the contract is concluded indicates that either party may withdraw from the contract. The person who has paid the earnest money and withdraws from the contract loses the earnest money, and the person who has received the earnest money and withdrawn from the contract shall repay double the amount of the earnest money, even if the withdrawal does not cause any prejudice. What is the definition of earnest money? In general term, or as a general rule, when a person makes an offer to another person and this offer has been accepted by another person, now we will have an agreement and we will have a contract, a valid contract. And this contract is irrevocable and it is binding on both parties. Nobody can cancel the agreement without having a discussion with the other person. This is the general rule, but sometimes a person may want a choice or a time for thinking more about the transaction. He might see that this transaction may need a lot of money and he doesn't have so he may pay a certain amount of money in order to have this option of thinking about the transaction. Now, the payment of this earnest money particularly happens in two situations. The parties may agree to pay a certain amount of money and loses this money if either one of them withdraws from the transactions. Now, the second situation by which the earnest money can be paid is to indicate the certainty of the contract in this transaction. Sometimes a person wants the agreement and wants the contract, but he further needs to make an assurance that he will continue on his commitment to this agreement. In this situation, he may pay a certain amount of money as an indication to his willingness, his full willingness to complete the contract. And in this case, this money is paid not for a choice. It is paid for maintaining the certainty, the full and complete willingness to have this contract enforced. Now, what are the implications of paying this earnest money? There are two implications. First, the money giver, the person who gives the money, if he chooses to withdraw from the transaction, in this case, he loses that earnest money. No more. Now we do have another situation. If a person gives money, this earnest money, to the other party, and the receiver of this money wants to withdraw from the transaction. And in this case, according to the law, he must pay twice the earnest money given. He must first give this money back, and he must pay the same quantity that he has given. Now, after we have figuring out the earnest money, we will deal with another topic, which is representation or التعاقد بالنيابة. التعاقد بالنيابة is a topic that is particularly governed by Articles 104, 103, 105, 106, 107, 108 of the Egyptian Civil Code. Also, students should be aware that there are two terms that closely connected with this topic, which is the principal, al-asil, and the agent, al-naib. What is the definition of representation? Representation can be, in summary, divided as a substitution of will from one person to another, and the consequences of this substitution is that the agent will act as if he is the principal. In other words, because of this substitution of will, the principal will be as imagined as he has particularly concluded the contract, but based on the agent's action. Based on the agent action. And for sure, if somebody wants another party to confirm or to make an agreement instead of him, or as his agent, he must draw a scope for this limitation, where this agent cannot deviate from this scope. Otherwise, the representation will probably be invalid, or the action based on this representation will be invalid. So, when this representation takes place, it takes place in three situations. First, representation can take place because of law. A provision of law may make a requirement on a person to be an agent of a person, such as the natural guardian for infant minor. Now, representation also can be because of a judicial decision from a court, such as representation from a guardian and the carter. The third situation by which, and mostly common representation form, is by agreement between the principal and the agent or the representative. You may personally have an agreement with your brother, your friend, or a person who has an experience about a certain issue. You may give him an agency agreement and ask him to go and confirm and make an agreement instead of you, because he does have an experience or because you don't have time to make the contract by yourself. These are the three cases by which representation can take place. It can take place by law, by a provision of law. It can take place by a judicial decision from the court. It can take place by an agreement between two persons, between the principal and the representative. So, in order to have a very accurate, a sound, a valid representation, two elements must be found. First, the agent or the representative shall act within the limits drawn for the representation's scope. What we mean by this? We mean that if you uh, asked your brother, for example, to buy a red BMW car and version 2020, your brother cannot buy another car like Mercedes or any another brand, or he cannot buy a red BMW car that is below the version that you require. Otherwise, this will be invalid representation. And you name it, any transaction, it must be executed within the limit of the representation. Second, when the agent makes the contract, he must put the name of the principal. It must be on the name of the principal and not the representative. Okay, so if we do have those two issues or two elements, we will need to know what are the implications of this accurate representation or valid representation. Three issues. First, all the contract rights, obligation are confirmed and held on the shoulders of the principal. As we have mentioned before, this is a representation for contracting, which means one person asks the another person to make an agreement. And by this, if the agent sign a contract to buy a car, for instance, the principal will have the obligation to pay the price for this contract, for this car. Another scenario, if you ask somebody to sell your car instead of you, and he made this agreement as an agent for you, as a seller, you have the commitment to give out this car to the new buyer and to make warranties for him. This is the first implication. The second implication for representation is that if the agent and the person who contracted with him are unaware at the time of the conclusion of the contract that the agency has expired, then the effect of the contract is that the principal will enforce this agreement. What does we mean by this? We mean as the following. If you ask somebody to be your agent in a transaction, but you have canceled this representation, yet the representative did not know that you have canceled this representation, or the person who will be the contracting person in this transaction didn't also have knowledge about the cancellation of this agency. If this scenario happen, in this case, all the contract, all rights and obligation will still be on the shoulders of the principal or his successor or his successors. And the principal or his successors cannot escape from these obligations or rights. The third implication of representation is that it is not permissible from the beginning. It is not permissible for a person to make a contract with himself in the name of his representative, whether the contract is for his own account or for the account of another person, without an authorization or a permission from the principal. And this is the general rule. But sometimes person may make a contract in the name of a representative or in the name of the principal or a name of somebody he knows, and this person later on he know about these transactions. Now he have two options. He may say no, I don't want to this transaction, or he may authorize this contract. He may authorize the contract and say, okay, I will take the responsibility for the contract and I confirm the actions of this representative. And in this sense, all the rights and obligations of this new contract will be on the shoulders of the principal. This whole issue should be done as long as this contract does not violate law or trade practices. By this, I conclude the presentation for this class, and please wait my next online classes. And if you have any questions, please contact me through either this email or through the Google classrooms. Thank you so much.